Good afternoon. My name's Annie Ostrager. I'm a partner in the litigation group at Sullivan and Cromwell, and today it's my pleasure to introduce Professor Stephen McDaniel, an associate professor of law at Notre Dame Law School. In preparing for this panel, we learned that we both graduated from Princeton, where Professor McDaniel earned a degree very relevant to today's talk in religion. Professor McDaniel also has a master's from the University of Pennsylvania, and we both graduated from this very fine law school, and then both clerked on the Second Circuit. Prior to his appointment at Notre Dame, Professor McDaniel practiced at two large law firms and has done significant research and scholarship on employment matters and the ministerial exception, which we'll discuss today. Professor McDaniel will provide an overview of the Supreme Court's recent religion doctrine, and will also touch on the doctrine of fair representation, and finally what's been unfolding on campuses in the wake of litigation against Harvard. And if there's time, I and maybe you all will get to ask him some questions on all of that.
Okay, thank you so much for having me. It's a real pleasure to be back here at NYU. I'll just say briefly that it's very intimidating to be in a room full of with so many practitioners and other professionals instead of students, because the only answer I know to questions is, well, what do you think? All right. So I hope that I do all right. Okay. So first, overview of recent employment and religion cases. So historically, there have not been a lot of religion employment cases at the Supreme Court. But over the past decade or so, there have been four significant ones. One on the church autonomy doctrine, specifically the ministerial exception. That's the case of Our Lady of Guadalupe v. Morrissey Beru. One on free exercise, Kennedy v. Bremerton. And two on accommodation of religious exercise under Title VII. The first is EOC v. Abercrombie and Fitch, and the other is Graf v. DeJoy. So I'll summarize, just give the basic outlines of the first three, and then talk some more about Graf because of accommodation issues that may arise in litigation. Graf is a fairly recent case, 2023, so the doctrine is not mature, but we can look at some things that might emerge over time as problems. So Our Lady of Guadalupe, this is a 2020 case. This involved two Catholic school teachers who were sued for employment discrimination. One of them for age discrimination and the other disability discrimination after a cancer diagnosis. It's very sympathetic plaintiffs in both cases. And both had some roles, how much was somewhat disputed, in the religious formation of students, but most of their time was spent doing what most sort of grade school or middle school teachers spend doing, teaching secular subjects in a secular way, not in a distinctively religious way. The court nonetheless held that the ministerial exception that prevents ministers from bringing employment suits against churches, churches broadly understood, applied in their cases and barred their suits. The way the court reasoned, it suggested that any basically non-trivial religious functions could be sufficient to make an employee a minister covered by the ministerial exception. This is something of a contrast with the previous and first ministerial exception case in the Supreme Court, Hosanna Tabor in 2011, which appeared to give substantial weight to a range of factors, not just the religious functions played by the employee, but also more intuitive things like formal titles. Do you call yourself father? Specialized religious training. How are you held out by, how do you hold yourself out as an employee? Do you consider yourself a minister? Speak to other people as though you're a minister. And does the employer categorize you as a minister? It seems all those things, while not irrelevant, are now very much in the background. And the main inquiry is, do you have any kind of significant religious function? One point to note about this case, Justice Thomas had a concurrence, one of his famous concurrences, in which he argued that the ministerial exception should apply to anybody that the employer in good faith determines to be a minister. This is characterized as a sort of rubber stamp doctrine. Given the friendliness of the Supreme Court to religious exercise and church autonomy, it's possible, by no means certain, that this is where the doctrine will end up, that essentially it will be reduced to what the employer says in good faith. All right, Kennedy v. Bremerton.
Just on that point, would
yeah.
that apply to employees or just, yeah, I'm sorry, would that apply to general employees like teachers or just people that exercise the religious functions to the employer?
We were just talking about that before.
Yeah, the people who exercise a religious function, but what counts as a religious function, I think, is going to be interpreted extremely broadly and deferentially if the Thomas concurrence holds a day. So it may, in fact, sort of, in effect, remove the religious function test. But this is just so far a concurrence in one case. And I think he was joined by Gorsuch, but no, it's not clear that there's an appetite for this on the Supreme Court.
But even under the majority opinion, there's a lot of deference to what the employer says is a religious function, I think.
Yeah, I think so. Or at least they don't want to look too hard at it for fear of making improper judgments. Who are we as a secular court to decide this is or is not religious? I think that's an inhibition, and they're going to resolve that tension most of the time in favor of deferring to the employer, I think. Kennedy v. Bremerton from 22, from Notre Dame, so football is very important to us. This involved a football coach who at a public high school prayed on the 50-yard line after games, initially alone, but later joined by players and other community members. So the facts are somewhat disputed, but I think that's accepted by all parties. The school district warned the coach many times that his prayers violated the Establishment Clause of the Constitution, and eventually they didn't renew his contract. So there are a couple of issues in this case. First, would permitting Kennedy's speech, his prayers, have violated the Establishment Clause? And second, was disciplining Kennedy for his speech a violation of his First Amendment rights to free exercise and free speech? So the Supreme Court came down in favor of the coach, in favor of Kennedy, saying, first of all, that, and probably most importantly, that his prayer did not violate the Establishment Clause because it was private speech, not government speech. He wasn't speaking in his capacity as a public school teacher or instructor. And the students were not coerced to pray with him, so it's not an Establishment Clause violation. The court did not apply the much maligned Lemon test and arguably removed it. The Lemon test, we don't need to go into the details of, but it's had, as Justice Scalia characterized it, this long sort of undead existence in the Supreme Court's jurisprudence where they never quite overrule it. And I think arguably they don't quite overrule it here, but they pivot in this case to a history and tradition view of what the Establishment Clause requires. So they look for historical analogs and say, of establishment of religion. And unless you fit within one of those analogs, you don't have an Establishment Clause claim. So that's the establishment issue. On free exercise and free speech, they say this was clearly targeting, treating religious speech as in a way that they weren't treating comparable secular speech. And so it was impermissible exercise with free, interference with free exercise. This case involves, I think, an important consequence for government employers. That is, there is apparently what has been characterized as no play in the joints between free exercise and free speech. It used to be thought, between establishment and free exercise. It used to be thought that if you were unsure whether there'd be an establishment problem, you could maybe restrain an employee's free exercise a little bit in the spirit of avoidance, of constitutional avoidance. But now it seems that you have to show that permitting the free exercise would in fact be an establishment violation. All right, EOC v. Abercrombie and Fitch. So as most of you probably know, Title VII prohibits employers from refusing to hire applicants to avoid accommodating their religious practice. So the Abercrombie and Fitch involved a 17-year-old Muslim woman who wore a hijab for religious reasons and was denied a job at Abercrombie and Fitch. Allegedly, it's a little unclear, but allegedly, at least in part, because the hijab conflicted with the company's so-called look policy, which was essentially required you to look preppy. That was what they said, essentially. Now, the applicant, when she showed up and interviewed, did not say that she was religious or had a religious motivation for wearing the head garment, let alone that she needed an accommodation if she was going to get the job. But the interviewer assumed that she wore the hijab for religious reasons. And that it seems, factored into the decision not to hire her. So the issue is whether Title VII's prohibition on refusing to hire to avoid accommodation applies where an applicant has informed the employer of the need for an accommodation. And the court said no, that all you need to show is that the desire to avoid an accommodation was a motivating factor of the employer's decision, not that the employer had actual knowledge of the need for an accommodation. So the takeaways are that an employer's duty not to discriminate based on religious practice does not depend on receiving notice from the employee of the need for an accommodation. The key issue is one of motive. Was the employer motivated by the need to avoid the desire to avoid an accommodation? Whether that the need for an accommodation was known, actually known, or merely suspected. All right, on to accommodation issues after Graf v. DeJoy. So, like I just said, Title VII requires accommodation of religious belief or practice. It does so unless, this is a defense, unless doing so would impose an undue hardship on the employer. There's a case from the 70s, Trans World Airlines v. Hardison, that at least ostensibly held that the employer could show hardship based on, quote, more than de minimis costs. That would be enough to show undue hardship. Now, the Graf case came down the pike and involved a postal worker who sought to be excused from working on Sundays for religious reasons, and this imposed various costs on the employer rescheduling around his restrictions. The court did not go into the merits of the case, but clarified, some would say overturned, but they never say overturned, the doctrine of Hardison on undue hardship. It clearly replaces the de minimis standard and replaces it with something like a substantial increased cost standard. But as the Solicitor General insisted at oral argument, in the era of Hardison, both EEOC guidance and judicial opinions applying Hardison or written in the shadow of Hardison were frequently much more demanding of employers than the de minimis language suggested. So we will just have to wait and see what difference Graf makes to actual outcomes in cases. There's clearly been a change or a clarification of doctrine, but it's not clear at all what this is going to mean.
Stephen, can I cut in for one moment? What do you do? My son-in-law is in the prisons, and the Sabbath, the days off are really important, that sort of thing. Mm-hmm. What do you do with someone wants the Sabbath days off, but all the other prisoners, all the other custodians do as well because they want the weekend?
Yeah.
What is the public employer supposed to do in that, or the private employer in that context? What do you recommend?
Yeah, I don't have a recommendation, but
what are the best steps or best practices? Or
yeah, so best practice. I mean, it's unclear whether you get to I'll come to in a minute, whether you get to sort of aggregate. You say, well, if we gave an accommodation to you, we'd have to give an accommodation to the other 25 people. If you can,
they don't have religious claims. They just want their weekends.
They just want their weekends.
They just want their weekends.
Okay.
They don't have religious claims.
You just don't give it to them.
Yeah. You just don't give it.
Yeah, I mean, it's an HR problem.
What if it's an HR problem? Yeah. But they get it as a matter of their contract, their labor contract.
If it's under the labor contract?
They have a right to have to bid for that work, but the Sabbatarian needs it for his religious observance.
Right, so there was a labor issue that is part of the facts in Hardison.
No, it's the same fact pattern. The identical fact pattern.
Yeah, so it's not clear what happens there. So I don't know how an employer gets around a situation.
So we don't know how
like
the
that.
verbal test changes. But it says substantial cost.
Substantial cost, yeah.
I would think there'd be pretty good arguments that you would have to make the accommodation to the person who's seeking the religious accommodation, which doesn't mean that the other employees will never have a Saturday off, or that some of them won't.
So you have to pay them, presumably, under the contract. Okay. I understand that. But the court didn't actually say that. It
The
just
court didn't say
court
that.
did
changed the
not.
verbal standard, because Justice White in Hardison used the silly verbal standard, de minimis.
Yeah, it didn't refuse to touch any, it didn't touch any precedents, in fact, which is why they insisted they weren't overturning it.
Right.
So they're,
We'll see.
This is not the only space where we've seen that from the Supreme Court in recent jurisprudence, I would say.
yeah, so we have to just.
It's been a
wait
very
and see.
creative court.
Yes.
Yeah. So some questions one may have in addition to the question of what do you do in like the Hardison fact pattern? How do you work out possible conflicts with rights under like collective bargaining agreements? You can ask, what's a cognizable cost? If this is the new standard, what makes it substantial and how to prove it in litigation? You can ask other things too, but I'll go through a few of these. So cognizable cost. So the general interpretation is that the ultimate touchstone in most cases is going to be monetary costs. There's a case called Carter v. Local 556 out of the Fifth Circuit, where a religiously inspired plaintiff, so this is religious exercise, sent a series of very aggressive and disturbing private messages to a colleague, which included things like images of aborted fetuses. And the court opined, and the defendant apparently agreed that under Graff, the defendant would have to accommodate such conduct, such religious practice, unless it imposed monetary strains on business operations. But notwithstanding that focus in that Fifth Circuit case on monetary strains, Graff does not in fact say that hardship is limited only to demonstrable monetary strains, and in fact says, and I quote, "Court should resolve whether a hardship would be substantial in the context of an employer's business in the common sense manner that it would use in applying any such test." So what counts as a hardship is a sort of basically a matter of common sense. And there are cases, for example, there's a case, Molina v. Boston Medical Center, that involve courts recognizing costs or hardships without reference to money. So there's the Molino case involved a COVID case involving vaccination mandates, and they said it would be an undue hardship to accept the risk of infection to coworkers and clients because the institution there was a hospital. Didn't have to go in to show that this would cost the hospital money. Nonetheless, employers defending refusals to accommodate in a particular way are probably well advised to identify pocketbook harms wherever possible. Also under cognizable cost, violation of law. So the general view is that there's obviously, is that if you have to violate the law in order to accommodate, then you don't have to accommodate. And this doesn't seem to have it doesn't depend at all on whether it's costly to violate the law. Otherwise, the law would sort of be at war with itself. But there can be problems where it's not clear whether an accommodation would in fact be a violation of the law. So just to take one example, there's a case out of the 10th Circuit, Balanchunk v. Cherry Creek Nursing Center, where the defendant employer could not win on the undue hardship issue at the motion to dismiss stage. This is a COVID case because they couldn't show, or at that stage there wasn't enough evidence that the religious exemption for the COVID, the state COVID mandate didn't protect them if they wanted to give an accommodation. So they said, we have to require this to comply with state law. And the court said, no, that's not clear enough. So you don't win, at least at the motion to dismiss stage. And there are other cases like that where there's unclear whether an accommodation would or would not violate the law. So it shows that there's a risk in denying even sort of legally problematic or accommodations. So you have to be pretty clear that an accommodation would be illegal to benefit from that, at least early in a litigation. Coworker impacts. This is an important one. It's very tempting to say, we can't give you an accommodation because the office would be in an uproar over it. Coworkers would be extremely upset for whatever reason. But Graff is extremely clear that costs attributable to coworker religious bias or to hostility to the idea of an accommodation are not cognizable. They can't get into the chain of causation. This fact could lead courts to take a more skeptical view of any references to coworker morale, which could just be seen as a euphemism for hostility to a religion in general, or to the idea of accommodation, none of which is allowed to count at all in the analysis. I'll just quickly do substantiality. So highly fact-dependent. The court says all relevant factors must be taken into account, including the particular accommodations at issue, their practical impact in light of the nature, size, and operating cost of an employer. What counts as substantial is likely to vary a lot from firm to firm. For example, there's a case in which at least a dissenting judge, but it could have come out the other way, said it was a jury question whether $300,000 to accommodate a single employee was really substantial or not. And that's because the defendant was Lionsgate Entertainment, a major production company. That's chump change to them, it was suggested, or a trier of fact could find that.
Not sure our clients would agree with that.
Yeah, well, they might not say it, but I think some clients know that it's chump change for them. But yeah, however that may be.
Now when it comes to paying our bills.
Yeah, that's right. Yeah, it's all the context. Yeah, so until more cases establish rules of thumb for particular scenarios, I think it's going to be very challenging for employers to establish substantiality as a matter of law early in a case. You probably have to play it out and wait for a fact finder to weigh in on whether a cost is substantial. How do you prove this? So it can be hard to prove monetary, specifically financial effect of particular workplace accommodations. That's a challenge. But it does seem there are some cases that suggest that you're allowed to speculate some about whether or not costs will be incurred. You don't need to wait for the costs to actually accrue, and the costs don't have to be certain. They only have to be possible. It's not clear how probable they have to be. It probably has to be more likely than not that certain costs will be associated with an accommodation, but you are allowed to speculate some. Okay, finally, I'll move on to what we may call the employer's duty of creativity, which is maybe the most challenging thing with Graf from a compliance point of view. So it's clear that Title VII, I'm quoting here, requires that an employer reasonably accommodate an employee's practice of religion, not merely that it assess the reasonableness of a particular possible accommodation or accommodations. So this seems to mean that once an employee requests an accommodation, the employer has to actively canvass and consider alternatives, not just wait for the employee to propose them. So this language seems to require that the employer actually think about possible accommodations, and so it behooves employers, I think, to do what in the disability space would be called an interactive process, to make sure that they've been creative, really thought about the possibilities. Because after the fact, in retrospect, there's always the risk that a court will say, you didn't think about option B, C, and D. And there are cases that I've seen where courts have said the employer didn't think about an obvious alternative. You can't rely simply on what the employee proposes. All right, duty of fair representation. How are we on time here?
We have about 5 minutes, and I think maybe a question on this point, right? No.
Oh, 5 minutes, okay.
I can maybe articulate what the question is, which is how is the employer supposed to divine what a satisfactory alternative accommodation would be to the employee, which is
Right.
different from what the employee asked for that can't be accommodated, or the employer is saying can't be accommodated, and like where does that leave an employer?
Yeah, so I think that the employers can probably cover itself by engaging in an interactive process. So you sit the employee down and you say, well, let's put our heads together. Is there a way? Is there a solution we can come up with? So it's true. It's easy to Monday morning quarterback these things. But if you create a space for deliberation with the employee, you'll probably get multiple ideas, and you can have a sort of good faith effort to suss it out, and that's probably going to count for a lot. But what I think is key is you don't sit back and passively wait for the employee to propose things and either accept it or not. It's not simply reactive, I think. At least that's how I read Graff, and that's what some cases have interpreted Graff to say. Okay, well, since we only have 5 minutes, I think I'll move over the duty of fair representation and just talk briefly about the duty of colleges and universities to protect Jewish community members from harassment. So we've seen an awful lot of this in the news with Harvard and other institutions, especially their response to the October 7th terrorist attacks. So I'll just speak briefly about Title VI. So it requires recipients of federal funds, including private colleges and universities, to refrain from discrimination on race, color, and national origin in federally funded programs or activities. Hostile environment is one recognized theory of discrimination. Different formulations exist in in various courts, but there don't seem to be any material differences among those formulations. They all seem to mean pretty much the same thing. You can summarize this as severe or pervasive harassment, motivated at least in part by the student's race, color, or national origin, notably not religion. That's not a protected characteristic. Where the institution had actual knowledge of harassment and substantial control over the harassers, and the institution showed deliberate indifference to the harassment. So harassment, probably the most important thing here is the deliberate indifference, because this is a demanding standard for plaintiffs to meet. It's a high bar to clear. It requires a showing that the defendant institution's actions were clearly unreasonable, not just suboptimal or questionable, given the known facts. And the bar is probably higher in the higher education context because of the First Amendment. So the First Amendment may limit what restrictive or punitive measures colleges and universities can be required to take. There's a case in the SDNY called Gartenberg, by far the most thorough case on this point, that is avoid constitutional avoidance principles to read Title VI as having a carve-out for so-called pure political speech. And the court proposed some principles for accommodating or not offending the First Amendment. The gist of which is that pretty much you have to focus on, the consequence of which is that you have to focus on things that are not classic political speech. So things like mere epithets, simply abusive speech, things that are of low value in the hierarchy of First Amendment values. So physically intimidating or humiliating acts, including speech that's directed at particular individuals or groups of individuals, and especially we've seen a lot in the cases, acts of vandalism, graffiti, or trespass. So you probably have a much better case for say graffiti than for a public speech or something like that. The courts are pretty clear that the mode of the speech matters. All right, so is this relevant to employees? So the cases I've mentioned focus on students, and Title VI has limited applicability to employment discrimination. There's a couple of ways in which it does, but we don't have time to go into it. But more significant, and I'll conclude on this, is that Title VI jurisprudence might influence Title VII jurisprudence. For example, it might make it easier for Jewish employees to seek protection under Title VII based on theories of racial and national origin discrimination, not just religious discrimination, because these campus cases are a proving ground for the racial and national origin theories. Or again, they might provide a framework for, the Title VI cases might provide a framework for balancing free speech values with anti-discrimination principles in the Title VII context. So with that, we can open it up.
We have time for one or two Questions?
Or we can go to you.
Yeah.
Hi, David Plato. I read Hebrew University in Cordova. I've read some commentators who have talked about the tension between the recent Groff decision and establishment clause jurisprudence, that if you're making even more accommodations for religion, that's butting up against the dangers of, third-party burdens or just privileging religious groups, et cetera, and that may raise establishment issues back to the 1980s with the Sabbath observant cases where that was a key concern that privileging could lead to establishment. Do you have thoughts about that?
Right, so I think in Groff itself, I think, this certainly came up in oral argument. I don't remember how much of it made it into the opinion. But they say part of the reason Hardison was decided and similar cases were decided as they were was to the mind of the Roberts Court, a false view of the Establishment Clause and what it requires. So I think under the Roberts Court, you would have to stretch to find an establishment violation. So it's not that there can't be a tension, but it's very unlikely under the current Establishment Clause jurisprudence focused on history and tradition that you'll find an Establishment Clause violation. But I am aware that there are people who think that there is a real establishment problem here if you end up favoring some group. But under the Roberts Court jurisprudence, I think that conflict is unlikely.
Right, that makes sense. I would just comment, like cases like Fulton,
Yeah.
there you're talking about treating religion the same as others, but here we're talking about
Favoring.
extending,
Yeah, and Title
Extending
VII
more,
favors religion, and this was considered problematic in the 70s, but is not, I think, considered problematic now.
I mean, I think the Bremerton case would have come out differently
Yes.
in a different era too, right?
Yes, undoubtedly.
All right, well, thank
Thank
you,
you.
panelists.
Thank you.
Thank you.